Hello, everybody. Peekaboo, Ava, peekaboo. I got Ava something special. I had to go to Ace Hardware to get, I had to drop off a couple of returns for Amazon. And they had zero, zilch, not a nothing for cats. But they had lots of stuff for doggies. So tonight, what do you think she should get? A or B? Are you picking? Are you picking? Which one do you want? Which one do you want more? You don't want to try the bully hide? You want bone? All right. A seems to be winning, especially with Ava. I used to go to the meat market and buy these, but I have not been to the meat market for a long time. I need to make a trip. I need to go back there. Get in line, Jerry. Get in line. Now, the last time I gave her one this big, she dropped it and scared herself. It was cute. Look, you want this? You can't even get your mouth around it. It's so big. I didn't say that. No one heard me say that. Oh, and then we have all these little broken off pieces of beef that just came off when I was trying to do that. Oh, she'll get them. She'll get them later. Hi, Billy. Hi, Billy. You looking for something? Yeah, you are? You're looking for something? What are you looking for? I gave all the treats that you didn't like. I gave them to the pound. Yeah. They were so happy, guys. I called ahead and made sure it was okay. And this was yesterday. And they said, come on, come on. So ended up donating like 6 or 7 boxes of 50 count iodine swabs. So they were a little dried out from when I first got them. I had them from my foot surgery, but they still had iodine, and they were no longer sloppy wet, but that means that they're perfect for applying, to an animal that has fur. It's not going to go everywhere. And they can get a little bit more precision with the iodine. And that's good for kitties with like bot flies, which happens a lot with strays. So, and then a whole case of Coban wrap, and a case of gauze, 2 cases of gauze actually, 1 flat and 1 rolls. All of the tubs of the 2 flavors of Bonkers treats. It's okay, Billy. It's just Tiny Kitten. All of those kitty curls, Marlene's toys that I'd gotten for the cats, they didn't have any interest in them. None at all. So I donated all of those. I had some leashes and collars and harnesses for both Ava and the cats that were extras. Donated those. There's just a lot of stuff. A lot of stuff. I donated a cardboard cat scratch house. One of those that you snap together and then they can go in. Tiny Kitten, what are you doing? She's getting all comfy underneath the self-warming blanket. Quit being weird. I am covered in kitty lick treat. But no, they were super happy. And honestly, I absolutely could not have done that without you guys. She's putting I guess they're putting it on their Facebook or something, and they're saying donated by the PAWFURM. Thank you guys so much. Hey, Billy, you want to get this, please? Come on. Hey, stop focusing on the desk. It'll still be there when you're done. Work on this. Now I have to order Temptations treats. Almost. You almost got it all. Thank you. That's good enough. Did you really seriously just knock the self-warming kitty bed off of there? Oh, you wanted to get onto the cardboard, weirdo. All right. Can I have this? You can continue licking the desk. I'm gonna hide these other tubes, or you're gonna expect them all. All right. Hello, Jerry Matthew Boyd. Hello, Buzzy Pug. I'm dropping stuff. Hello, Nana Laura. And yes, I do know Methany fell. I have to call the fire department to pick her up. She's way too heavy for me. I'll get her back up there. It's just going to be a little bit of a minute because I need help. So, okay, quickly cleaning cat treat off my desk. Alrighty. Pick this up. I did take a video while I was in the 2 cat rooms that they have at the pound. And I kid you not, they have a full family of what was feral black kittens that are the exact same size as Tiny Kitten Esquire. And their tails are just as floofy. Like they are spitting images. I am pretty sure that they're all Tiny Kitten's family. It was crazy. It was absolutely crazy. They sound like her. They look like her. And I know her mom is the one that's, been going into the Coleman Castle outside. Hello, Michelle Moreland, my absolute sweet love. Welcome, sweetie. Hello, Joey Bag of Donuts. Hello, Wire Mother. Hello, Purple Kiv. Ava has me trained. Not gonna lie. She has me trained. Every time I see a new treat in a gas station or somewhere, I'm like, ooh, what's the ingredients? Would Ava like it? Excuse me. I'm sorry. Hello, Eileen and Carlin. I'm really hoping the internet stays up tonight. Last night was embarrassing. And the last case was a good one. A good one. It's an update to one we've already seen. Hello, Jenny Green. Hello, Mortimer Duke. You are Ava tired, huh? Oh, I think you were tired last night too, so does that make you retired? Sorry, I couldn't help myself. Hello, Charlie. I have no hot gossip. My tea is cold as cold can be. For once. It's gotta happen once every blue moon. You know, twice a year. Hello, Mark Addy. Hello, she's a maker. Hello, Spider-Man. Did I get everybody? Did I get everybody? I'm working on it. Hey, can you drag that a little ways away, please? I can hear you. You can have it. Go have it. Take your bone and go. Clean up all the little tiny pieces that broke off. Okay, yeah, you're right. You're right. I have 4 cats and a dog. I don't need another one. But it was pretty cool. A couple years ago when I stopped at Chasing Daylight, a friend of mine was getting a cat and they had him on special. So excuse me. So I went with her, and there was this cat in cat country that had a scar right here. It looked like he had a cleft lip. And his name was Roger. And I fell in love with Roger, but I didn't have a place to live at the time. I was staying with my friend that was getting a cat, but that wasn't a permanent situation. So I wasn't able to adopt him. But when I was talking to the gal, I was telling her about the kitty with the cleft lip. And his name was Roger. And she's like, I remember Roger. The original story with Roger, they thought that Roger was hiding in the engine of a vehicle to stay warm, and somebody started the vehicle and he got his face cut. But they stitched him up really good and they found him a good home. Chasing Daylight is amazing. That is the animal shelter that when I was hospitalized and I was refusing to allow them to admit me because Ava was in the kennel, they sent a worker to my house every day that I was hospitalized, a couple of times a day. That's the pound that kind of saved my life. Aww, that's so cute. They had so many cats there that were talkers. I did take a video. Originally, I was gonna live stream it, but couldn't do that because I had an appointment with my healthcare facilitator person. I guess she's somewhat of a social worker. She comes in and makes sure that I have all the medical supplies that I need. And right now they're working on trying to get me a new handicap ramp because mine is super, super dangerous. But she was here today and had to go through the full report. I was expecting a quick visit, but I should have known better. Yeah. My daughter was going to apply to volunteer there because animals are a big part of her field of study, but she didn't. She had something else going on over the summer that she wasn't able to. But she's going to some kind of special summer camp this summer for her class, and she gets credits for it, so. We're not talking glory holes, Jerry. All right, so let's see the last two hearings that the internet cut off last night, and then we'll go on to some new stuff from today. I love you guys so much. I really do. I love you guys. Going to work.
Okay. I will give him a call.
Magistrate Cooper. Amanda will not be present as she's in Judge Hesslink's waiting room. She's waiting for a hearing there. She is okay if you proceed without her. I just wanted to let you know.
Okay. Thank you.
Hello?
Hello, is this Mary Smith?
Yes, it is.
This is Judge Cooper. How are you today?
Oh, good, thank you.
Good. Is Annabella there?
Yes, she is.
Okay, good. Annabella, how are you doing?
Here, just a second. Oh, she's right here.
All right.
Hello?
Good to talk to you, Annabella. Mrs. Smith, we need a new, or at least I need to make sure I have your correct address. The thing we sent got returned.
Oh, well, I know my mail got screwed up because of the weather.
Sure. So it's the same address we've always used?
Yeah.
Okay. All right, we'll continue that, Kylie. You can just, I guess, use the same one. This is a show cause. Ms. DeFider is the crux, the basis of the show cause, the 10-day suspension, school suspension.
Yes, Your Honor.
All right, Annabella, do you understand what this hearing is about?
Yes, Your Honor.
Your rights are and just so you know, Mr. Delaney is here. You can't see him since we're doing this by phone, but he can hear you. You'll be able to hear him. And this is a recorded hearing. Your rights include the right to an attorney. That's Mr. Delaney. You have the right to a contested hearing. At that hearing, probation would have to show by a preponderance of the evidence that this is true. If probation could not do that, it would be dismissed. At that hearing, you'd have the right to have you or an attorney ask questions of witnesses against you, and you'd have the right to have the court order your own witnesses to be present. Do you understand your rights?
Yes, sir.
All right, Mr. Delaney, did you hear what the order to show cause is about?
Yes, I received a copy and I anticipate that Anna is aware also, unless those need to be summarized for her.
Well, it's just basically the 10-day out of school suspension. So how would you like to proceed on the hearing then?
Annabella, kid, this is David Delaney. Can you hear me?
Yes.
Okay, we've had a few of these before, and my position is always the same. If this is not true, we would defend you. If it is true, it's my recommendation that you simply tell the court that it's true and explain your position. Do you understand?
Yes.
Okay. Do you want to tell the court what happened?
Oh my goodness. Nothing says I have zero faith in your case like that right there did.
Annabelle, do you mind if I simply inquire of her, Mr. Delaney?
Yes, that might be easier. Thank you, Judge.
Annabelle, if you could raise your right hand, and do you promise to tell me the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Did you receive a 10-day out of school suspension?
Yes, Your Honor.
What happened that caused you to get suspended?
I just got caught with a vape on me.
Okay. All right. And Mr. Fighter, that's your understanding as the basis for it as well?
Yes, Your Honor.
Okay. All right. All right. Well, I will find you responsible for that violation then. Ms. DeFighter, what are your recommendations?
Annabella complete her previously court-ordered 150-word essay on the long-term effects marijuana has on the brain and turn it into the probation department by March 20th, 2026. Annabella complete her previously court-ordered 150-word essay on how my drug use will impact those around me and turn it into the probation department by March 20th, 2026. Annabella complete her previously court-ordered 50 hours of community service and turn it into the probation department by May 8th, 2026. And Annabella create a list of 12 reasons why school is important and turn it into the probation department by March 20th, 2026.
All right. Mr. Delaney, any comments on those?
No, those are reasonable recommendations from the department.
All right. Ms. Smith, Mary Smith, anything you wanted to say?
No,
Okay. Annabella, anything you wanted to tell me?
I just want to say that part of the reason why I didn't get like the packet, like the essays and stuff done, I've been really sick for like honestly like a whole month now.
Okay.
Like, cause I had a really bad sickness, and then I was not sick for like a week, and then I got super sick again. And I just want to say that that's like part of the reason why I haven't been able to do it. I forgot what it was about, but yeah, it's just been an awful month. That's all.
All right. Well, you do sound somewhat under the weather, but I know you also know what you need to do. I will adopt those recommendations as the order of the court. Well, basically, any of these things aren't really consequences. They're things you have to do, but it's helping you to understand how important school is and how important it is to perhaps change some of the other things you're doing. But I will take care of that, or I will order that. Ms. DeFighter, anything else you'd request happen today or anything else to add?
I just want to add one comment. As far as the recommendations go, I did order this 50 hours of community service that I am extending today on June 17th, 2025. So Annabella has had 6 months to get 50 hours of community service done, and I have yet to receive any of that. As for the essays go, I did order those roughly a month and a half ago, so that would make sense why Annabella does not have that done.
All right, so Annabella, you just need to complete those. Hopefully some of the sickness will get better with the change in the weather, but Ms. DeFider, how many of those 50 hours does she have completed? Do you know? Do you have an idea?
Last time I was inquiring on it, I was told that there was 3 hours completed.
3 hours in a year. That's all she could pull off? Something tells me she doesn't take this seriously.
That's like what, 15%? Annabelle, actually, it's 6%.
Yes.
You need to get on it, Annabella. You just do. Time to grow up a bit. Okay, that does conclude this hearing then. Thank you very much. I'm going to be hanging up now, Mrs. Smith.
Thank you.
Have a good day.
All right, calling cause number 25-02-0144-CVA.
Guys, I don't know if y'all remember this. I put the link in the description, but this is, hold on. I was going to put it right on, and then I forgot. I was going to put it on the case. This is this couple. He's in a band, and she has a hippie lifestyle, and thought that his mom watching the children and him watching the children was just a temporary arrangement while she got her life together. And that lasted 2 years before she gave a crap. So that's this hearing. She's got a lawyer now.
In the interest of the Schutt children.
Good afternoon, Your Honor. Mary Escamilla here on behalf.
Thank you very much. I'm going to be hanging up now, Mrs. Smith.
Thank you.
Have a good day.
All right, calling cause number 25-02-0144-CVA. In the interest of the Schutt children.
Good afternoon, Your Honor. Mary Escamilla here on behalf of Kyle Schutt, move-in and petitioner.
Your Honor, my name is Ruben Rodriguez. I'm here for Ashley Ray Hancock.
All right, 1 second. All right, this court has set this matter to show cause why it should be not be dismissed for want of prosecution. I don't think we've seen anything since temporary orders were filed with this court in October of 2025.
Yes, Your Honor, may I respond?
You may.
As you know, we had a full-blown temporary orders hearing, and the parties have been living under those temporary orders since that time. My understanding is that respondent filed a motion or request for a jury trial with a jury demand. And we have not yet mediated. We would like to mediate. I think this case has a very good chance of settling at mediation. Mr. Rodriguez, I emailed Mr. Rodriguez about that. He emailed me back stating that his client cannot afford mediation and he would like us to pay 100% the cost of mediation. He also asked that we mediate at the Travis County Domestic Relations Office. I contacted the Travis County Domestic Relations Office to see if they could do a pro bono mediation. It's my understanding that they won't mediate if the case is not pending in Travis County. I did let them know that one of the parties is living in Travis County, but because the case is not pending there, I don't think they can do a free mediation for us. So my proposal today would be that I think we have a mediator that is really good, a strong mediator. I've used her in many of my family law cases before. She does a lot of attorney ad litem and guardian ad litem work. I think she'd be a great fit for this case. We checked with her calendar. Last I checked, I think she has March 19th available. We're following up because that date was available yesterday, so I'm not sure if it's been booked now. But we are willing to pay for 100% of the cost for a full day mediation for that mediator. And we'd hopefully get into mediation soon. And then hopefully we can resolve it that way. And I guess I'd like some clarity on whether or not Mr. Rodriguez and respondent intend to move forward with their jury trial demand. I understand Mr. Rodriguez said he's now working for her pro bono. And then the other issue is just a slight housekeeping issue. We don't have to address it today if the court doesn't have time, but we had our other order from that temporary orders hearing submitted and has not been signed yet, and that's just the order on the Rule 11. If you recall, Your Honor, they had filed a Rule 11, and we asked that there was an order on the motion to strike his respondent's Rule 11 and their motion for sanctions, and we just asked the court sign that at some point.
So I don't have anything to sign. So if when was that submitted?
Well, we submitted it to Mr. Rodriguez, but we could never get him to agree to our draft of the order.
Not the attorney, the Ashley Ray Hancock, the mom of the case, she seems awful weebly wobbly in that little box of hers. She's been doing this the whole time. Not that dramatic, but she's had a full weave going for this whole hearing so far.
And so it's still kind of hanging out there. I didn't know if this court wanted me to send it to you to review via email submission, or if you wanted to have that set for a different date for a Zoom hearing on that, or if you wanted to handle that matter today.
Well, it's not set for today.
is
So
not.
unless Mr. Rodriguez wants to try to settle it today, it's not set for today. So Mr. Rodriguez, do you want me to try to handle that today?
I am here today on your order that requested us to appear. The answer is no. I'm here on an order that you issued on providing you information as to why this case should not be dismissed. I'm always appalled as how counsel twists things around, injects things that don't pertain to the hearing, and always disparages as that I never provided her an answer.
All right. So we're going to set this for a jury trial. When do you want the deadline for discovery, and when do you want when do you want to have a jury trial?
Well, I want to address your motion.
My motion?
You set an order setting a court proceeding that a party's failure to adhere to show cause as to why the matter should not be dismissed. And that's what I was invited here to do.
Correct.
Now, if we're going to address something else, I would like the opportunity to prepare for that. I don't like to be surprised here like we did last time, where I was promised a 2-hour hearing, and then we spent 1 hour on a frivolous motion for sanctions so we can put money in counsel's pocket on something that has nothing to do with the best interest of the children. And it's like,
all right, Mr. Rodriguez, I'm done listening to all that business. What do you want to do? You want to set this for a jury trial? Yes or no?
We have already requested that. We want to dismiss the case because there's no reason why this case should be dismissed. I asked for mediation. My client has asked for mediation.
Mr. Rodriguez, here we go. I'm going to stop you again.
The mediation discussion did not start until this order
Mr. Rodriguez,
was by the court.
I want your silence, please. I'm going to set this. I'm going to do a docket control order. I'm going to set this case for a jury trial.
May I speak? Because he and I have
Ma'am, no, you may not. You have an attorney here to speak for you. So, Mr. Rodriguez, I'm going to set this for a jury trial.
We'll kind of respect all the letters of unavailability, all the dates. I didn't come here with my calendar. I don't have it in front of me. If the court now wants to address setting this case for a jury trial, it may do so. We have requested mediation. We have asked for mediation. That's been ignored. And it's interesting how counsel can couch a different story, and that's listened to. But when
Mr. Rodriguez, I didn't listen to her side of the story either. If y'all want to mediate, go mediate.
Yes.
If you think we're being unfair, then whatever. I just need to get this thing rolling. It's been sitting around since October. This thing's not moving in a positive direction. This hearing is for me to get it moving in a positive direction. So I'm going to do a docket control order. And if y'all want to do mediation, then knock yourselves out. If you can't agree on mediation, then set a motion for me to make an order for mediation.
Your Honor, in my motion to retain, I had a request for a motion for mediation as well, and that was set for today. So I would like you to order us to mediation today if you can, Your Honor. And like I said, we have a mediator in mind, and if she has availability, we could go like, I think she said March 19th was yesterday when we checked was the available date, by
All right,
Zoom.
Mr. Okay, hang on. Mr. Rodriguez, I got a bunch of cases set for this time because I'm not having I have like 3 cases set for a half an hour period of time. So I don't have time to listen to all this stuff. So, Mr. Rodriguez, do you want to have mediation ordered as requested by Ms. Escamilla?
We have requested it. Yes, we have requested it. Don't act like we never requested it. We requested it. We insisted it. It's on the temporary order. So don't act like we
Okay,
didn't.
Mr. Rodriguez, enough. The mediation as requested by Ms. Escamilla is so ordered. So get me an order for mediation, Ms. Escamilla.
Holy cows, dude. Who do you think you're talking to? You are being so disrespectful to the judge, to the court, and to your client by acting like this. My goodness.
And I'm going to set this thing for a jury trial. Should we set it in July?
I don't have our calendar. I think July may not be a good time.
Would you like to set it in June?
No, let's go late July.
Well, these are the dates. I have a docket call on July the 9th, pretrial setting on July the 20th, and jury trial on July the 27th.
I don't have my calendar in front of me, but I think July the 27th may be the most appropriate.
I'm going to go ahead and set it for those dates. I'm going to issue a docket control order if we have a problem with the docket control. And I'll make motions and get the case back in front of me. But right now, I'm retaining the case, setting it for a docket call on July the 9th, pretrial hearing on July the 20th, and jury trial to begin the week of July the 27th at 8:30 a.m. And I will sign a docket control order and have that submitted to the parties shortly.
Thank you.
All right, that is it. And also, as I previously ordered, I've ordered the mediation as requested by Ms. Escamilla. Ms. Escamilla, get me that order, and I'll sign that once I find that in my e-file.
Thank you, Your Honor. We'll include the name of the mediator.
Could I also have her provide me the name of the mediator she's suggesting that they were willing to go with?
Yes, I happily will do that. I can email it. And I'll put it in the order as well, Your Honor.
Okay.
Thank you.
All right.
But does he have his calendar with him? I don't know if he brought his calendar. I think he might have forgotten his calendar. Where's his calendar? Ali. He was so rude.
Up in Nisqually there on the Lacey case. Actually, I'm going to need a minute here.
Oh, good. What happened? Hello.
Yeah, I'll be with you in a minute there, sir.
Thank you.
Okay, now, what's your name, sir?
My name is Arvin Kola. Arvin Squally.
Did you say Arvin Kola?
Yes, Your Honor.
Okay, and then Ms. Garisco, you're here for Mr. Kola?
Yes, Your Honor. In speaking with Mr. Kola, he was advised of his rights, and he's affirmed that he understands them. We'd like to waive formal reading. We'll stipulate to probable cause for this hearing only. We'd also like to enter a plea of not guilty. We do represent him in his DWLS third degree case. In talk with him, he's indicated that his income has not changed. So we would ask for direct appointment to our office as well. Thank you.
Did you have a position on probable cause and did you discuss with him his legal rights?
I did, Your Honor. We would like to stipulate to probable cause just for this hearing.
Mr. Kola, you're now charged with 1 count of malicious mischief in the third malicious mischief, domestic violence related. That's a gross misdemeanor, carries with it a maximum penalty of 364 days in jail and a $5,000 fine. Plea of not guilty will be entered. This matter will get set for future hearing. We're going to set conditions of release. I will appoint the Pacific Point Law Group to represent you. And I'm going to hear from the city on conditions conditions of release. And then I'll hear from Ms. Garisco. Mr. Sharp.
Thank you, Your Honor. The city is asking for $5,000 bail on the newest case, not taking action on the backup D3 case. Quick note on that, though. It looks like a warrant was issued and then served, and then he posted bail. So today's the first appearance on that case. So speedy would start. We're not asking for bail on that one, but for $5,000.
He's got a pretrial set for March 24th, but go ahead.
Okay, thank you, Your Honor. So again, $5,000 on the malicious mischief DV charge, law-abiding behavior that Mr. Cole not possess any firearms or other dangerous weapons, that he surrender any firearm or concealed pistol license that may be in his possession or control, that he not consume any alcohol, marijuana, or non-prescribed drugs, nor go to bars or taverns, as drugs appear to be a factor in this case. Finally, that he abide by the terms of domestic violence no contact orders presented that would protect his 13-year-old nephew. I did include a civil standby provision in the order presented to the court today. The bail request is hefty, Your Honor. The city believes it's appropriate here. We do have a hint of flight risk, given that he's failed to appear on the other Lacey case and has other warrant history. But the primary concern here is safety and the likelihood of future violent crimes. This incident is pretty concerning. It looks like Mr. Cola lived with his sister and two nieces and a nephew. The nieces and nephew were all home. His sister was not. Nieces are aged 20 and 18. Nephew's aged 13. All of these people said that they believed he was on methamphetamines that night. 13-year-old nephew was in his bedroom. Mr. Cola, while under the influence, believed someone else was in the room with the 13-year-old who shouldn't have been. Took an axe and started chopping at the door, breaking a hole in the door. He fled when police were called. 13-year-old was pretty shaken up by this. That fact pattern is pretty concerning, Your Honor. It's even more concerning when we notice that Mr. Cola has some criminal history with domestic violence history. Going all the way back to 2011, he has an assault second conviction with a deadly weapon, and that's tied in with a DUI and a controlled substance possession without prescriptions charge. So it looks like the mix of substances and violence go pretty far back. Concerning as well as in 2023, there were 2 convictions for violating a no contact order. With that in mind, especially, the city believes that a PR with a no contact order is not sufficient here. He's already shown a proclivity to violating those orders. So with all this told, city believes 5,000 and those conditions are appropriate.
Ms. Garisco?
Your Honor, we would ask for Mr. Cullen to be released on his personal recognizance. He does have the presumption of release on non-capital cases.
What? I know that it's not a capital offense because he didn't actually, unalive him, but he was this close to it. He very easily hopped up on meth, could have completed that task. Oh my goodness, you have the gall to ask for a PR bond? Really?
He does have some warrant history. It's not extensive. We would ask for him also not to have and the no contact order imposed. From my understanding, Mr. Cola does not financially the people that he lives with are the ones that support him financially. In addition, he does have that 2011 case, but that was a long time ago. Yes, he does have a 2023 case that ended up in a conviction. However, he hasn't had anything since then that is a conviction. So I would ask for him to be released on his personal recognizance from 2011 until 2019. He had no charges at all. So we would ask for him to be released on personal recognizance. If Your Honor is asking to impose any bail, he has already paid $1,000 in bail for the driving while license suspended under the 3rd degree. So it would ask for no extra bail to be imposed to Mr. Cullen. Thank you.
Based on what's alleged, neither just allegations there, Mr. Cola, nothing's been proven beyond a reasonable doubt. I am going to set some bail in this case. Bail is going to be set in the amount of $2,500 cash or bond. That's based on the facts and public safety, as well as recent warrant activity in the other case. You've just had a warrant here and you've had warrants in other cases, but in the case it's other current case, you have a warrant out of that case as well and just posted on that. Your next court date is March 24th at 10:30 on both cases. If he's still in custody at that time, then that'll need to get reset to the in custody calendar. And here's the thing here, I am signing a no contact order. You're not to have any contact with your nephew. Do you understand that? And if that means you have to move out, you need to move out. Do you understand that?
I understand that. I'm going to reside in Tacoma.
I'm sorry?
I'm going to reside in Tacoma.
Okay, yeah, you can reside wherever you like. You just
Well, he is going to reside in Tacoma. Didn't you hear him, Your Honor? It only took me about 15 times of listening to it to decipher that's what it said. That's what he said.
you can't have any contact with him or reside with him.
So, yes, Your Honor, the last time I bailed out, I put 100% on the $1,000 bail. I gave her 1,000.
500, and again, you can consult with a bail bonds person, but based on what's alleged, that's what I think is an appropriate amount.
2,500, as you said?
Sure. And then,
Honor,
Ms.
if we could go over the
mailing address as well as a cell phone number for text reminders.
Your Honor, I did send that to the clerk. From my understanding, I do not believe the address has changed, but I had told her about the phone number.
No, we got it. Thank you.
Thank you.
That's it for
Your
today
Honor,
there, Mr. Kohler. You can be taken back.
Your Honor, before we wrap up, I wonder if we could go over those conditions. I heard the court mention bail and then the no contact order. Are there any other conditions being imposed?
Yes, I'm sorry. He's not to consume any alcohol or have any controlled substances out of valid prescription, stay out of bars and taverns, and don't refuse a breath test, as well as don't possess a firearm or other deadly weapon, and of course, the no contact order, which I mentioned.
Thank you, Your Honor.
Now you can be taken back, Mr. Kohler.
Thank you.
Your Honor, I
At
believe-
Olympia up there, what's your name? You, sir, Nisqually? With the beard? Your head bowed a little bit? Are you with us? Do we know who this is, Ms. Oh, there you go. Someone's going to wake him. All right. Yes, sir. What's your name in the beard?
Donald
Just not you, the other one,
Norris.
the other one from the city of Olympia.
Norris.
What's your name?
Norris, Steve, first name Steve.
Ms. Dutch, you're here with Mr. Norris. So it looks like an arraignment on a criminal trespass. Ms. Dutch, did you get a chance to speak with him regarding his legal rights?
I did, Your Honor. We spoke about his legal rights, and at this time, we will waive further arraignment. We'll stipulate to probable cause for purposes of today's hearing, enter a plea of not guilty to each count, and request a court-appointed attorney. Mr. Norris does receive public assistance.
Do you have a position on probable cause?
Yes, we can stipulate for purposes of today.
So, Mr. Norris, based on comments of Ms. Dutch, I will appoint a public defender to represent you. You're charged with 2 counts of criminal trespass. Those are both simple misdemeanors, carry with them maximum penalties of 90 days in jail and a $1,000 fine. Pleas of not guilty will be entered on both counts. I'm going to set conditions of release. I'm going to hear from the city. And then following that, I'll hear from Ms. Dutch. It's okay. It's okay.
Thank you, Your
Don't worry
Honor.
about it.
The concerns with Mr. Norris is that it seems that he has been trespassed from by the city of Olympia. One of the, I believe, the park employees was trespassed him back at the end of January. At that time, he refused to take the formal paperwork about that trespass, but it was explained to him verbally by this employee. And then since then, he has more than once violated that trespass by coming onto that location of the docks and the Harbor House area. So law enforcement did serve him another 12-month no trespassing order for that location as well yesterday. So it should be made very clear to him that he is not allowed in that location at all, and is to stay away from there. We're looking at his criminal history. It looks lengthy, but most of it, I believe, are infraction related. The most recent thing he has right now is from December, an attempt to elude and possession of a controlled substance. Those are pending charges out of Superior Court. So I don't have an objection to a PR release today on these trespass matters. Just no law violations and do not return to that location.
I can do that.
Ms. Dutch?
No objection to those conditions, Your Honor.
And what's the location? You kind of described it, the docks area, but is there a more specific way to describe that?
Percival Park.
As well as called,
Say that again there, Mr. Norris?
so there's Percival's Landing, which is the Olympia Center. And then you also got Port Plaza, which is part of Swantown. So it'd be Swantown and the Olympia Center, Percival's Landing.
Yeah, do you understand you're not supposed to be there?
I understand it now.
Okay. And then Ms. Dutch, did you provide cell phone number and mailing address?
I did. I provided that in an email to the clerk earlier.
I'll appoint a public defender to represent you. You're going to be released on your personal recognizance. Continue to release. Conditions of continued release are don't have any criminal law violations, don't have any contact with the Percival Park, and make all your court dates. Your next court date is going to be April 9th at 10 a.m.
Thank you, Your Honor.
And that's it for today.
Thank you, Your Honor.
You'll get released later today. We'll see you back here on the 10th.
Or the 9th, correct, Your Honor?
9th, my mistake, sorry.
Mr. Norris, you can just step out that door behind you.
And then the Olympia, you sir in the beard there, what's your name?
Weta, Henry.
Okay, great.
Your Honor, Jennifer Lamari, on behalf of Mr. Weedham, I was just appointed yesterday, so I'm not sure if it shows up on the court's docket that I'm the attorney of record.
Okay, and then what's happening today?
Yes, Your Honor. So I just got this case yesterday. I did get discovery just today, and I did get a chance to communicate with the prosecutor. I also got a chance to speak with Mr. Weedham at the jail. We don't have a resolution today. I'm just asking for this to be set over 2 weeks to the 19th at 1:30.
Okay, and then does Mr. Wedham, do you know how to get a hold of your attorney?
Yes, I talked to her today.
And then you folks in the back, did you hear all that? Basically, the attorney's now on board. She needs to speak with him, and then we'll reset this. We can do this 2 weeks today. Is there any chance he's going to make bail?
I don't know, Your Honor.
Okay, so I was asking them actually, but we'll just reset it for 2 weeks at 1:30. And if he does make bail, he'll still need to be here at 1:30. All right.
Your Honor, the city was going to suggest that we just keep the confirmation date, which is April 2nd. And then if there's a resolution or if there's a matter that needs to be brought before the court, defense just set it. Otherwise, we could, be taking up our already significant docket time with this matter.
And I object to that. I don't want.
Yeah, we're going to just, Ms. Lamari, just we're going to go ahead, given the nature of where he's at. I'm going to go ahead and set a pretrial there, Mr. Carver. And if nothing comes of it, that'll be much like this one. That'll be a quick hearing. And then if there's a resolution, there's a resolution. So I don't mind spending, may or may not be me who's the judge, but I don't mind spending the time. So we'll reset it for 2 weeks from today at 1:30. Did you have a question, ma'am?
Yes. Is there any way that the date can be reduced?
You need to speak with, I'm not going to do that today. And she has an attorney now. The attorney can get that on for a hearing to discuss that, but that's been set. And generally bail doesn't change, I should say. Bail stays the same unless there's some sort of change of circumstances from when it was originally set. And I was not the one who originally sent it, so I'm not familiar with what was available then versus what's available now. Also, the prosecutor needs a chance to respond to a request to change all that. So do you have contact information for how to get a hold of Ms. Lamari there? Okay. Ms. Lamari, do you have a phone number I can give to Mr. Wedham's family here?
Yes, Your Honor, that's fine. My attorney number is.
And then hang on just a minute. I'll give you a post-it here in a minute. Is your first name Jennifer?
Yes, Your Honor, Jennifer.
All right, I'm going to give your phone number to his family members. Come on forward, ma'am. Oh, actually, here you go. There you go, on the highlight and on the post-it. That's the contact information for the attorney. You could talk with her about bail and things of that sort. And that's it for today. You're free to go. Mr. Wedham, that's right. I said Weedham, but it's not right. It's Wedham. Mr. Wedham, you can be taken back. Ed Nisqually, what's your name, sir, in the beard?
Strout.
These are warrant returns on a sanction hearings.
That's right, Your Honor. The court found violation, non-compliance with chemical or domestic violence treatment on both these back in October of 2024 and reset sanction to give him a chance to get back in compliance. Instead, he failed to appear for court. Warrants were issued and they've been out for a little over a year now. Those are no bail warrants. The city believes that's the right amount unless we're able to resolve the sanction today. And the city is able to make a recommendation. Pacific Point represents him, so I would think we'd be able to move forward. There's no fact in controversy. The court already found the violations. But if the court's not inclined to proceed on sanction today, I do have a bail recommendation.
Ms., who's here with, there's someone from Pacific Point standing in with, for Mr. Strout? Ms. Garisco, there you are.
Your Honor, his attorney of record from looking at JABS was Amelia Hickok. So I was unable, I had not talked to Mr. Strout, but I can talk to him, call him in a breakout room, but I believe his is the last matter for Lacey.
So this warrant has been out for a couple of years?
A little over a year, Your Honor. It went out in December of 20.
What we can do there, Ms. Garisco, is given the amount of time this warrant's been out and how old these cases are, we could just reset this a week, give you a chance to talk with him, and then just hold him till then, and then come back a week and figure out where we're headed with this.
Your Honor, I'm happy to talk to him now in a brief breakout room.
Okay. You kind of had me at brief there. And so we have a big calendar and we're not going to, things aren't going to come to a screeching halt.
Yes, Your Honor, he's the last matter for Lacey. I don't know if you'll use it for
but it's not my last matter.
Yes, Your
and
Honor.
So you can go into a breakout room and then we can come back in a few minutes.
Yes, Your Honor. Thank you.
Ms. Garisco, where are we at with Mr. Strout?
Your Honor, in speaking with Mr. Strout, he's indicated to me that his financial situation has changed. So we would ask, in talking about his financial situation, I do believe that he will qualify for a public defender. Our office does have a conflict with Miss Amber Hernandez, so we would ask for him to be appointed to Miss Langley's office.
What days does she appear in the afternoon calendar there, Mr. Sharp?
I believe Wednesdays, Your Honor.
So Mr. Strout, given the age of this case, I'm going to direct that you be held. And then I'm going to set a court hearing for Wednesday, this coming Wednesday at 1:30. We'll do it on the in custody. And Mr. Sharp, if you wouldn't mind letting Ms. Langley know that where he's at and what the situation is. It'll be March 11th at 1:30.
I'll reach out to her this afternoon, Your Honor.
And that'll be on for a sanction hearing on both cases.
Thank you, Your Honor. I believe that's the last Lacey case on the calendar today.
Did you say anything?
So Mr. Strout, you can be taken back. You'll be next court date. It'll be
Your
Wednesday
Honor?
at 1:30.
Your Honor,
Yes?
my attorney didn't say anything that she told me she was gonna say. Cause I've never missed a,
Okay, so Mr. Sharp and Ms., did she go already?
I think so, Your Honor.
Okay. Well, I don't know what she told you she was gonna say, but what I know is these cases are several years old. The warrant's been out for well over a year. These cases need to resolve. You're gonna be there till next Wednesday, and then you can figure this out with a different attorney.
well, I would just like to tell you what happened was all. Why I missed court. I didn't even know I had a court date. I've never missed a single court date that I knew I had. And at that time, I was in the hospital for a blood clot in my leg that I almost died from. And it took me about 6 months to even walk again.
All right. Well, you're gonna be here again. You can discuss that with your attorney. We'll see you back here Wednesday at 1:30.
All right.
You can be taken back. And then Mr. Woody, I saw you come on. You're here with Mr. Cruz.
I am, Your Honor. Apologies, we're having a difficult time figuring out which courtroom he was supposed to be in here. But I'm here on behalf of Mr. Taylor and Mr. Cruz. Miles, if you can mute on your side.
So Mr. Cruz, you're gonna need to be a little bit more quiet because I didn't hear anything your attorney said. But Mr. Woody, why don't you take it from the top there?
Miles, can you mute your, thank you. I'm here for Christopher Taylor for Mr. Cruz.
Okay. So he's here on several pre-FTCs and then trial confirmation on some others.
Correct. We are asking to continue the newest trial and the bench warrants quashed if possible. Mr. Cruz is currently in inpatient treatment, and Mr. Taylor is not available for trial right now. He's already in one. That's why I'm here on his behalf. So we're asking to continue the most closely set trial.
Give me just a minute. Where is he at in inpatient treatment? What
Lakeside,
facility?
Milam.
No, that's not true. I'm in recovery.
Oh, apologies. Just discovery recovery?
Yeah.
Okay. Ms. Pinkston.
Your Honor, we would object to any sort of continuance. These are all hearings that Mr. Taylor was hell-bent on setting. So we set these cases. We also set him for a fact finding on Monday that the city was prepared and has subpoenaed witnesses for. Mr. Taylor failed to appear at that hearing and had coverage at that time. Judge Wilcox found him in non-compliance for part of the issues that he's on non-compliance for. Half of it is his failures to be in treatment and go to probation. The other half are these new law violations. So she found him in non-compliance for these new law violations. At that time, we had a no bail warrant on both of these backup matters, and that's because he had bailed out of custody and then failed to report to probation. As of the Monday of the hearing, Oswaldo from probation, who I believe is in the courtroom today, he received information from Mr. Cruz the last Friday at 4:30 saying that he was going to Lakeside recovery centers, and that's where he was on Monday. However, so at that time, Judge Wilcox, we were under the impression that she had already quashed those no bail warrants because we, quote, knew where he was located. However, I do see that those are still in the system. Our concern that day to the court was that we don't have any real proof that he was actually at that center because he had not signed release information to the probation department. So Judge Wilcox had said if we don't get proof that he's in treatment by this Thursday, that she would reissue those no bail. Well, the probation department did get proof on Monday.
Hang on just a minute. Mr. Cruz, you need to stay on camera. Thank you.
The probation department did get a letter saying that he had entered treatment on the 28th. And then we also got a letter on the 3rd saying that he had been discharged from treatment. He did not make it past an inpatient phase of treatment. So I don't know where he is right now. We don't have a sign release form, but the city, as well as probation, who I would defer to them, I think they're in the courtroom there, are interested in getting these cases wrapped up. He's already been found in noncompliance. Today is set for sentencing. We have zero faith that at this point, Mr. Cruz will follow through. I can't even count how many times he's told me he's gotten impatient and he's either been kicked out, left early, never followed through. And this is the same argument that we make to the court. Every time we're here, he's already been found in noncompliance. We need to move forward with sentencing. Some of these issues are from 2024. And we just either he fails to appear in court, he gets a warrant, it pushes back out, the court resets it, and we're in this cycle where he's just built up no goodwill with my office or probation by this time. So we want to go forward with sentencing, and I believe we're ready for trial.
So you over Mr. Cruz's shoulder, what's your name?
My name's Justin Franzen. I'm an RN here.
And where do you work?
Discover Recovery in Camas.
And where is that?
It's in Camas, Washington.
I see. And how long has Mr. Cruz been there?
Since this morning at 7:30, around 7:30 a.m.
So he's been there for, he's even been there for
several hours now, yeah, since 7:30 a.m. this morning.
You're honestly looking at Mr. Cruz right now. It doesn't even look like he's lucid to be a part of this hearing.
That's why I asked how long he was there.
And I believe it would be proper to set this over for, again, this isn't Mr. Taylor shirking his responsibilities. I believe he's in Thurston Superior right now in trial.
Wow. So he told them he was going to rehab, left the rehab early without ever signing the consent forms, got picked up again. Or no, he didn't get picked up. He checked himself into rehab the day of his court hearing. That's an awful convenient timing. Yeah. And he is high AF.
So there's a warrant in place in 2 cases. I tend to agree with Ms. Pinkston that I'm not sure Mr. Cruz is in position to proceed right now. And that's just based on my observations. And so we're just going to reset this for 24 hours, which means he's going to be back on the calendar at 1:30 tomorrow. If Mr. Taylor is in trial in Thurston County Superior Court, I know they don't do trials on Friday. So you can communicate with him that he can be here at 1:30 tomorrow.
Okay, which room is that in?
And deal with all these cases. What'd you say, Mr. Woody?
Which courtroom?
That'd be number 3, I think. Yep.
Okay, thank you.
You need orders from me? Can you just set those over? So again, given his condition, I'm not really comfortable going forward here today. And so, and again, that's just based on my observation. He's almost like on the verge of losing conscious sometimes. He's having difficulty keeping his eyes open, it looks like to me. In fact, they're closing right now, so I'm just not comfortable proceeding when he's in that condition.
That's fine with probation.
And so we'll just reset it. We'll just be back here in 24 hours. And if he's not in that facility anymore, there's a warrant, there's a no bail warrant on that. That's going to remain out. So we'll try this again tomorrow on all these cases.
Okay,
Sorry about that.
Yeah, no problem. Thank you.
Thank you, Your Honor.
You're welcome.
And if the facility can make sure he's available tomorrow, I'm not sure about blackout. Thank you. Appreciate that,
Hey,
sir.
Mr. Cruz, please make sure you sign a release of information for Thurston County District Court probation with your treatment provider.
All right, sounds good.
You're welcome. Give me just a minute.
And Miles, you might want to talk to Mr. Taylor on that before you sign anything, okay?
Yeah, definitely.
Okay.
So before we go, I'm going to go back to Mr. Strout in a minute.
You're good to go, Miles.
I'm good to go.
And
Yeah,
Mr. Cruz,
good
you
luck
can
with
sign
that
off
tomorrow.
now, but you need to be back in this courtroom at 1:30 tomorrow, courtroom 3. And I'm
Yes, Your
speaking
Honor.
mainly to the person over your left shoulder there.
Yes, Your Honor.
Thank you, Your Honor.
Thank you.
That's my only matter in this court.
Aw, I hate when it ends. You very well may be right, Jennifer Love Spewitt. That is an absolute possibility. But he's the nurse, but how many body cams have we seen that involve a nurse? Oh, he did. Right on the money right there. Absolutely. Yeah. Yeah, I don't know if he's gonna make it through I mean, it's like 3 days of hell, depending on the substance, of course. But I don't know if he's gonna make it through day 1 at this rate. Oh, Ava's happy. She's chewing on her bone and she is not bringing that thing in the bed. Nope. I'm gonna just smile and nod. I don't know. I've not seen it. I'm sorry. All right, guys. It is 1 a.m. I am going to crawl into bed and get some sleep. Maybe. I always say it, and then it never works out that way. But I really appreciate you guys coming and hanging out with me for all that craziness. If she does, I blame you for giving her the idea. Be safe, be well, sleep sweet, and much love.